This is Impact Healthcare, people and strategies that are disrupting the health benefits industry. And now, here's your host, healthcare benefits industry expert and the originator of the transparent health benefits movement, Lester Morales.
Man, am I excited. I don't know that I've ever had an attorney and been excited about something, but I am super pumped about this conversation because although typically we think talking to an attorney is that we got in trouble or there could possibly be trouble, I think this conversation for our Impact Healthcare crowd is going to be so enlightening on the things that we should really be thinking, unlike the things that we're probably told. And I've got a special person that if you Google her name, which I did, and then there's 1,900 awards and smart things that she's done. Julie, for the Impact Healthcare crowd, give us an introduction of you, your number one, your firm. And I'm going to start with some questions right after that, but give us an introduction.
Great. Thanks, Lester. I'm happy to be here. My name is Julie Selesnick. I'm Senior Counsel at Berger Montague, and I'm in the Healthcare and ERISA Benefits Group. So I began my career practicing for about 23 years now. I began as a defense attorney, spent my first 10 years on that side of the V, realized I made a terrible mistake about 10 years in and switched sides, and have been working in the employee benefits space ever since. And, especially particularly healthcare, where there is just ton of work to be done to sort of fix up what the current system, how it operates, and make it work better for people and for employers in this country.
I love it. And when I was doing research, I'm going to read you a statement in your own bio. And it basically says you are also focused on the legal violations related to patient health care under various federal statutes and state consuming statutes to help everyday Americans bring down the out of control healthcare costs. So I don't think anybody's born with that, desire, right? You didn't get out of bed. I kind of feel that people like you, there was something that happened. There's a why, there's a motivating factor that gets you out of bed. Can you share that with us?
Yeah. I've always sort of been on the side of the underdog in most cases anyways, and just take the side of the party that has less power. And here it's just an unbelievable dichotomy where one side holds all the cards and the other side, us, Americans, really have no idea what we're paying, what something's going to cost in advance, if, one episode of medical care is going to break us and ruin our entire rest of our lives. And, you can look at anyone and think there, but for the grace of God, go I. It's one of those situations where unless you are truly a multimillionaire, any one medical situation could ruin you in this country. And so I find that very motivating. I am motivated to help make a system that we are definitely going to stick with. America's had the chance lots of times to decide if we want to go with a more single payer or public payer health system. There's clearly a consensus in the country that at least for now, we're going to stick with employer-sponsored insurance being the main vehicle through which Americans get their insurance. So if that's the case, then it needs to work better. And so I'm really motivated to do that, to make it work better. I think that part of the reason why wages don't increase is because of the amount of money spent in healthcare. And I just think if we could fix things up there, a lot of good things could happen for a lot of Americans.
So I love the motivation, and I'm going to guess that you have seen so many things that an employer comes to you, a group comes to you, somebody comes to you, they think one thing, but the reality of it is another. I'm going to call this part of our show the Myth Busters, or Julie's going to tell us what most employers and advisors are doing wrong. And I thought the easiest one was around the HIPAA conversation. I got into this business. I was 22 years old. I was selling self-funded, and I would go to brokers and I would say, hey, we just need the claims data so that we can underwrite it, blah, blah, blah. And they'd be like, my carrier tells me that I can't get any claims data and I can't use it because it's protected under HIPAA. Can you give us the real answer in layman's terms as to what an employer can and can't do with health information? What does HIPAA actually say versus not say?
Absolutely. And that's a great way to start. I see HIPAA was supposed to be enacted to be a shield to protect employee, personal health information. Instead, it is now being used as a cudgel or a sword by the people that hold the data as yet another reason why you can't have it. And, so basically what HIPAA does is protect personally identifying personal health information. And what it says, you can only share it with a few sort of covered service providers. One of those covered service providers isn't actually the employer, although it is the employer. It's the plan. And so when the employer is acting as the plan sponsor or acting on behalf of the plan, that is what gives the employer the right to the claims data that is part of their plan. And to be a proper ERISA fiduciary, you need that claims data to make decisions to ensure that claims are being adjudicated properly, the way your plan documents are written. For a host of reasons, plans are obligated as fiduciaries to get this claims data, to review it and make decisions based on it. So if you're told, one, that you can't have the data, so this happens a lot, for instance, when a fully insured plan wants to explore moving to a self-funded plan or even explore other options in the fully insured world. They try and get sort of, stop data so they can figure out high dollar claims, how they could get a stop loss quote, things like that. And they're told, no, you can't have that. This would be a HIPAA violation. And if that's, you should definitely push back against that. If you're asking as the plan on behalf of the plan absolutely has a right and an obligation to get this data and to make good decisions prudent decisions based on what the data tells them. The plan also has the right to share this data with their covered business associates under proper privacy protections. Everyone in this space is used to entering confidentiality agreements and things like that ensure the privacy of what is shared, and that PHI will be shared, will be handled sensitively. And if there's any sort of breach, it'll be handled properly. As long as you follow those safeguards, absolutely, plan and their fiduciaries have the right and the obligation to get their data. That HIPAA is not a bar to that, and they have the right to share it with the business associates as long as they share it under proper confidentiality protections.
So let's dig a little bit, because I want to draw the distinction between a fully insured group and a self-insured. So I am fully insured. I am paying fully insured premium to that carrier. The argument that's always told in that is because you're paying premium to somebody else who is taking the risk, that they are the fiduciary, and then therefore the data doesn't have to be shared with you as the employer because you aren't the plan sponsor in that scenario. The plan sponsor is the carrier. Correct? Not correct? Myth? Not myth? What dig into
Total
that.
perfect. It's number 2 on the Mythbusters list, because you, the plan, if you are the plan sponsor, you are almost always a fiduciary. And whether or not the carrier is a fiduciary in any circumstance, that does not mean that someone on the plan side is still not a fiduciary. The plan administrator.
I want to ask that. So if I am paying Blue Cross and Blue Shield, Aetna, Cigna, whoever, fully insured premium, I am the employer, I'm paying it to them. Am I still technically the plan and therefore the fiduciary? Or am I relinquishing that obligation and also therefore then that risk to the carrier? What's the technicality there?
Here's what you can never relinquish: the duty to monitor any service provider you hire. So even if your plan buys an insurance policy from Blue Cross and says this is going to, inoculate us from risk, it might inoculate you substantively from what's under that policy, but you still and always have an obligation to supervise that service provider and ensure that they are following your plan documents and they're still your plan documents. And so that is where you still have to get the claims data. You still have to figure out what you're paying in compensation and make sure that these are reasonable, prudent costs.
I hope that most employers heard that and just ruh-roh. I hope that was the deal. So now we'll move over to the self-insured side. So now I am deciding as the employer, I am taking on true responsibility, true management of my plan. Talk to me about the things. And we've already crossed over to ERISA too. So let's play between HIPAA and ERISA. What are the things that you see most common myths and or just complete omissions from an employer's responsibility in that side?
So, the self-funded world is a great world, but it, comes with a lot more risk for the employer right now. I think that employers think right now that they just became fiduciaries for their health plan because of the Consolidated Appropriations Act. So this is another huge myth. You've always been fiduciaries. It's the same. It's always been the same in your health plan as it's been for your 401k plan, your pension plan, things like that. However, I do understand why plans haven't felt the same sense of urgency to act there because the DOL hasn't sort of expressed the urgency to act there until very recently. So and if you've noticed, sort of all of the litigation in the employee benefits space, particularly the ERISA space, has been around excessive fees in 401k plans. And that has been sort of, the huge talked about topic. Oh, plaintiffs, class action lawyers, they keep suing employers for excessive fees. And, and that certainly what has been a very lucrative industry for the past 20 years. And those plans have been largely cleaned up because of that litigation. And so the fees have become much lower and much more reasonable. And billions of dollars have been restored to people's retirement funds because of that. Well, now take that and multiply it by I don't even know. And that's what's happening in health plans. And unfortunately, employers are just sort of we're late to the game. Everyone's late to the game, and realizing that, wow, this is my number 2 line item. So if you're an employer, your health plan is probably your number 2 expense after payroll, and you have no idea what's going on there. So unfortunately, I've never seen such a Stockholm syndrome in any area of my life where everyone thinks this is just how it is. You don't ask questions. The system is what the system is. My broker's going to tell me how much my costs are going to go up next year. I'm going to say, thank you. May I have another? I'm going to just take it, and that's how it is. And there are no options. And it's sort of like, people sort of, I think here, the people that have the most to gain have set the narrative on how things work, and everyone else has sort of accepted that that's how things work without pushing back for a really long time. Well, all of a sudden, in 2021, we get these new rules under the Consolidated Appropriations Act. And this is like a spending bill, Congress's annual spending bill. But for some reason in 2021, it contained a bunch of provisions that drastically changed the way health plans are monitored by federal agencies, and what the obligations for disclosures all of a sudden became much higher on fiduciaries. So now the spotlight is on health plans, and it is giving employers tools. So the good part is that all of a sudden employers have these tools that they never had to be able to really try and figure out what is going on in their health plan. Why am I spending all this money? How can I get this under control? But with that comes a lot of risk. If you, especially not doing these things and not getting control and figuring out what's going on, is your biggest risk, because you are a fiduciary. And once you have this data, you have to act on it and make decisions on it, even when they're hard. And this is an area where it's really hard to do anything in the face of extreme resistance. There's extreme resistance to change. There's entire industries that their livelihood is staked on not having change. And so it's sort of like pushing a boulder uphill in both directions. And people have to just be patient, because there are rewards at the end, but this is the hard part.
So when you think about the CAA and you think about, all of the obligations that an employer has, what are your top 3 that you're like, there's a lot, but if you're late to the party, start with, kind of 1, 2, 3. What are those 3 things?
So the number 1 is getting your claims data. And, it's number 1 because nothing else works if you don't get your claims data. None of the other new obligations can really be properly followed if you don't have the data. And so, of course, because that's the most fundamental and the most basic, it's the most difficult one to get. And it is a hill that a lot of us are dying on right now. And, it's being played out in, negotiations across the country, in RFPs. And then when things really go south, in courtrooms throughout the country. And plans are, there are a number of plans that are either employer sponsored or Taft-Hartley, union sponsored or union employer sponsored, that have sort of jumped out in front of this and are sort of trying to blaze the trail for everyone else and say, hey, you have to give us this data, or else we cannot exercise our fiduciary functions the way we are required to under the law. And so I would say getting the claims data is the number 1 most important thing that all employers should be concerned with and have a plan to do right now. Number 2 is so once you have that data, though, just getting it isn't the only thing. Then you have to act on it. And that data is the basis of all your plan decisions. So it's really understanding what to do with it once you get it is very important, and how to use it to make strategic decisions. Number 2, understanding the compensation you are paying all of your plan service providers. This is what all the litigation on the 401k side has been about. Excessive fees, and people right now have no idea what they're paying, particularly their third-party administrators, their pharmacy benefit managers, because there's a lot of hidden fees, undisclosed fees, formulas that aren't given, and so understanding that is key. And then number 3, I would say it's got to be sort of mental health parity reporting. And this is because this is where Congress and the Department of Labor are certainly focused, and CMS, if you're in a non-federal governmental health plan, not governed by ERISA. This is everyone in the country, every regulator's focus and every lawmaker's focus. And so there's money there to sort of enforce here. So without your claims data, you can never do this analysis. And even with the data, it's very difficult to complete this analysis without cooperation from the third-party administrator, and that, which is why we're 3 years into sort of enforcement here, and the Department of Labor is still finding that 99% of the reports, when they look at them the first time, are wrong.
So we've mentioned the word litigation lawsuit, and your name is attached to a big one, which I'm going to, on behalf of those of us that are trying to do something, say thank you for leading that way. Obviously we can only talk about what's in the public domain, and I'm completely fine. But for those people that might not even understand what it was about and all of that stuff, there was a lawsuit filed against Anthem, and it was your firm, and you were lead on that. Can you walk us through like the highlights of it, and what do you see coming out of that could help our audience not go through that same, although I'm asking you to cut your future compensation maybe for people that might hire you, but what is it that we should be taking away from that?
That's great. And trust me, the goal is to work myself right out of business here and find something else to focus on. So we've joined some good company here in trying to hold third-party administrators accountable for doing what the law says they have to do. So in this case, we represent 2 unions in Connecticut, the International Union of Bricklayers and Allied Craft Workers, Local 1, and the Sheet Metal Workers, Local 40. And for both, for a variety of reasons, they were having difficulty getting their claims data from their third-party administrator, which is Anthem. And, but you can read in the complaint that sort of each client went through their own set of torturous negotiations for months on end, trying to get their claims data until it became apparent that they weren't going to be able to get what they're entitled to and what they're required to get under the law. And so we became counsel for both funds and filed the lawsuit. And so the basis of the lawsuit is, first of all, you have to give the claims data. The law says you have to give it, and you're not giving it. And in fact, you're relying on gag clauses to keep it. And, if you look at the motion to dismiss filed in that case and in other filings in other similar cases, you will see that the carriers are still asserting gag clauses and saying, hey, just because the law says there's no gag clauses doesn't mean that we can't have confidentiality provisions, and you should negotiate better if you don't like it. That's really where they're at on their response right now. So, there's sort of a disconnect between your contracts don't trump federal law. They never will. And, there's not a recognition yet that sort of federal law trumps what these contracts say. So I think that that's going to be a really useful measure that comes out of, if not this court, then one of the courts that are dealing with this issue. And then second, at least in the case that we filed against Anthem, when the plans do get access to some data, it doesn't make any sense to them. So you get a limited amount of information, and then you try and analyze it, and you say, well, this isn't the price that it's supposed to be. This doesn't match the discount that I thought we were getting. And you realize that, this is an unfortunate, add this to the Mythbusters list, is I love all the new transparency rules. I love that there's hospital price transparency. I love that plans can get claims data, when it works in a perfect world. But even in a fully realized plan, you get all your claims data. The hospitals have posted prices. You can compare. Guess what? You still often don't know what you're paying, and it still doesn't match. What's still missing is the piece where what other terms in the agreement between the carrier and the provider are affecting what they're going to pay for your claim. And that is covered in the gag clause removal provision, but somehow it hasn't been the focus yet on getting the provisions of the provider agreements that also affect payment. So we also argued that in the case that we have right to those as well. And, something like, so there's, that's not the only case like that. The Kraft Heinz has recently filed a very similar case against Aetna. Same reasons, and seeking the claims data and sort of alleging that the data they do have suggests some real malfeasance, saying, that there's been a lot of impropriety in claims processing. There was a case filed by mass laborers in the First Circuit, against Blue Cross Blue Shield of Massachusetts. And, based on a procedural decision on whether or not that administrator is a fiduciary in the First Circuit, it didn't end up being successful in court, but it doesn't mean that the claims won't ultimately be successful, because they're the same type of claims. And there's been a couple others filed against Anthem in Eastern District of Virginia by Owens v. Minor, which is a private corporation. And I believe that case ended up sort of resulting in a settlement where the claims data may have been turned over, and we'll see more about that. So there's, we're not the only case out there. There's a few others, but again, they're very difficult to bring because employers or Taft-Hartley plan sponsors, it's very difficult to get plans to file litigation. They're nervous that they're not going to have access to a third-party administrator and that they won't be able to give their employees good healthcare coverage. So it's really an area that's difficult to bring a lot of meaningful litigation in, and it will work much better once there's one or two decisions that can be used as a basis for negotiation rather than a ton of future litigation.
So if we think about that, then part of this is, one, obviously realizing, your rights and, expectations and et cetera. But some of this, if we're thinking about this correctly, is also whoever your representative is, making sure that on that front end, the negotiation and what you're asking for, demanding, expecting, whatever word we're going to use, sets you up for success. Is there any level of advice that you would give to somebody? I remember when I was sitting in the advisor seat, when I was working for a large firm, I a lot of times would write my RFPs that says, as a condition to win this bid, you must agree that I need this data in this format on this frequency. And I would give them the template, because what I found is, hey, we'd want to put that client's data in a data aggregation tool. We'd want to put it in an on-site clinic. Well, I need data and I need you guys to play together so I can do all this. And then the carrier would turn around and be like, yeah, we can give it, but it's not going to be in that format. We'll give it to you once and you're going to pay us $2,500 every time. It's like, wait a second. So any advice that you would give to advisors and employers that says, based on understanding where the gamesmanship is, I would recommend you guys doing this?
Absolutely. So first of all, you just gave great advice. And that is one of the pieces of advice I often give, is you'll never have more leverage than you have in the RFP process. Ask for what you want then. There's never a better time to get what you want than when you ask for it and someone is still competing for that business. And you put in writing what you expect, so you should expect to get bids that are based on what you've requested. So one thing we are seeing is that there's a movement where the TPAs are sort of agreeing that there won't be gag clauses, and they're certainly telling you they'll help you with your attestation to say there's no gag clauses, right? And filing your attestation. But that doesn't mean that the gag clauses have actually been removed. So here's my biggest piece of advice there is, one, don't rely on the word of a TPA saying, oh, yes, there's no gag clauses in here. You can use this to file your attestation. You, the plan fiduciary who files this attestation, or even if a TPA files it on your behalf, you're responsible for this statement. And so don't file a statement that isn't true to the federal government. That's a really bad idea. And how do you know if gag clauses have been removed if you haven't looked yourself, if you don't know what a gag clause is, if you haven't retained someone outside of the people saying that they've removed them to sort of corroborate this? Yeah. Otherwise, you're just like, that is the classic fox guarding the hen house. Oh, yes, we're completely compliant with the law. We'll attest that for you, and it's your responsibility. That's a sort of crazy thing to do. So what we are seeing, even when employers do try and sort of get more involved in this and negotiate it, is a sort of a fake compliance. The third-party administrators say, yes, let's get rid of those gag clauses. And then we see them shifted into the confidentiality agreement that the employer is then asked to sign when they go to actually get the data. So one thing I always recommend now to clients that are employers or plans is to have any confidentiality agreement that's going to be a requirement under this administrative service agreement to be sort of appended to the administrative service agreement as an exhibit, so that it's part of it, so that there can be no gag clauses there either, and you can't be hit with a surprise down the road. And so, a lot of carriers will say, well, this is what our confidentiality agreement looks like. Here's a sample of the data request that you'll send with it. But that sample is not useful, because if it's not agreed to up front, then there's actually nothing in the gag clause removal provision that would prevent gag clauses from being in a confidentiality agreement. It undermines the spirit of the rule, but it's not technically against the rule. So that's an important thing to do, is make sure that you sort of work that out up front.
Man, that is some ninja things right there. Man, that's amazing. So, when we think about put your crystal ball on, and think, obviously where these lawsuits are going, where the movement is going, if you put your crystal ball on, or if you had your druthers, what would this look like post all of this?
So, if I had my druthers, it would look a lot different after all of this. But the best outcome I can see is sort of, so right now there is a movement to sort of bolster some of the holes in the CAA provisions and plug the gaps that currently exist in getting your claims data, getting compensation disclosures, thing like that, to sort of make them more robust. And one of them would be, for instance, right now, one of the problems I see with it is, if you don't get your claims data or can't get your claims data, the penalty is 100% on the plan, right? Except the plan is 100% dependent on a third party to comply. So one of the possible cures is to add, penalties on non-compliant service providers. And that is actually in a bill that's currently being debated in the House right now, that would, impose a daily penalty on non-compliant service providers. I think that's sort of a necessary compliance step. I do think that, one or two court decisions will change the way that they do business in that area, when it looks less that it might not be worth it to sort of continue on this road. That's what makes change. And you can already see some change even without these rulings. There's sort of a recognition that, like, well, maybe we should sort of shift our guard focus in different areas, because this one is now going to become very expensive and we're going to get bogged down in this argument. We don't want to be there. So again, it's shifting into like the downstream agreements, later confidentiality agreements, trying to argue on what vendors you can use or not, which, by the way, is a gag clause. And one thing we do notice is third-party administrators now coming out with their own products just to compete with the vendors that you would hire to supervise them. So here's something that, plans should be cautious of. You don't want to hire people to monitor your service providers that are the same people as your service providers. This is just a bad idea. And it's like, my son would love it if he was in charge of grading his own math tests, but I would not give him that role, because I don't think he would really do a great job at that. I think it's wonderful that his teacher does that. And I think that there should be a sort of third party control. So I think that's the case in your health plan too. The duty to monitor, you cannot delegate that to the group, the service provider that you're monitoring, because that is, again, that's where we are now, and it doesn't work. So really, what I think will come out of this is a much more robust fiduciary role in health plan management, where fiduciaries do sort of begin monitoring more carefully, like they currently do on their 401k plans. And they start to think of what's in their plan as like their investment lineup, and care as much about the choices their employees have for healthcare as they do that about the choices their employees have to invest in. Because even though it sounds crazy, there is no recognition right now that this is as important. And at the end of the day, this is where we're headed, is once we get sort of the access to information and out of control costs under control, then we really will shift more to like, what is the quality and value of this plan? Is it worth it? Is an employee really getting a benefit from this? Are there health equity issues? Are you sending employees to hospitals with terrible outcomes? Are lower wage employees going to hospitals where there's a higher, female mortality rate in childbirth, or things like that? And so I think the future is going to shift to quality and value. So right now is the time to get cost and oversight under control, because that's the future. Awesome.
I welcome that future. So man, this has been, I've written more notes down on this session than I have before. And I want to end it maybe with, in our webinars, we call them our parting shots. I'm going to give them, the free advice from Julie. And I want to kind of leave three different constituents: the employer, the advisor, and then everybody that will put their ears or eyes to this podcast will be a consumer of healthcare. And it's my belief that until we make a better educated, a better consumer, process, and that's going to start from the ground up, we have to educate ourselves. Nothing that we could do up here is going to be truly as impactful as it could start from the ground. So let's start with the employer. What's Julie's one recommendation for the employer as we exit this?
Is to become much more engaged in managing and overseeing the health plan that you offer your employees. It is, again, after payroll, the most expensive thing that your company is spending money on, and you're not getting your money's worth. Right now, you are not getting your money's worth. You don't know why your costs are increasing double digits every year. We've just been told again, costs are going to go up 8.5% for 2024 with no explanation as to why. All of a sudden, a report has just come out that self-funded plans are paying more for certain, covered procedures than fully insured plans. This is because people aren't paying attention. And so I do understand why up until now, if you're an employer, it's been very difficult to get any sort of grasp on these issues, but now's the time. And I'll tell you right now, there are plaintiffs' attorneys out there that have, brought class claims in the 401k space that are already pivoting and looking for plaintiffs that are, your employees under your employee-sponsored health plan, looking for employees that are disgruntled and might want to sue you in a class action case for your improper management of your plan. So if you don't like all the litigation that's occurred in the 401k space about excessive fees, this is about to be replicated, and whether it's successful or not, I don't think that most companies want to be defending lawsuits saying that they're, mismanaging their health plan. So right now is the time to sort of course correct. There's new tools available to you. You don't have to be perfect, but you just have to try and try and be a good fiduciary. And if you don't know what that means to be a good fiduciary, then you need advisors who can tell you what it means to be a good fiduciary and give you the sort of soup to nuts of what to do, for starting with, do you have a committee that discusses how to manage your health plan? Or is this 100% falling on Betty in HR? That's not fair, and certainly the people in HR are not equipped to do this without, a lot of guidance and training and assistance from the C-suite and from other people in your company. And so you really have to become part of this and not just leave it it's not a ministerial HR function, and it's an extremely important function of your core business, and you really need to take better control of it.
I mean, it's funny, this week alone, I have met with several employers that, hey, my carrier tells me I can't carve out my PBM, I can't carve out my stop loss, and my broker confirmed it. They also confirmed that there's no other carrier that can handle our business. And I was like, so Jimmy, let's just say that the client's name was Jimmy. I was like, Jimmy, let's just take ourselves out of nerd talk. And let's just common sense think about why those statements were said. And do you think that the doctors that are in the communities in which your employees live only take one carrier? That's what you're thinking. And that they're a 135-year-old business. You, for the next 135 years, are only going to be with that one carrier? And
he's like, great point.
I've never really thought about it like that. I'm like, I just want you to do this. Call Dr. Jones and ask him if he'll take cash. If he'll take cash, we'll figure out a way to pay him in some other mechanism that isn't the blind leading the blind in this conversation. It's maddening because it was a firm that is a big, large firm that's billions and billions of dollars in revenue, hundreds and hundreds and hundreds and thousands of employees. And a lot of these bigger clients are getting advice from these bigger firms. And it's like, oh my gosh, like what's going on?
Well, so can we just drill down on that for a minute, because that's great advice. And really, another thing I would recommend to employers is engaging an advisor that will give them advice like this, like what you're giving. If your broker is confirming what your carrier told you, you already have a problem. The broker is supposed to be on your side. They're not supposed to be representing the carrier and sort of being their mouthpiece. So if that's what your broker is currently doing, you have a problem and you should seriously contemplate switching brokers. What you need is an advisor who will tell you common sense. And that's what you're doing. And also encouraging employers. And that's, I would encourage you employers, think out of the box. There is more than one way to have a health plan. You don't have to have a Blue Cross or the United symbol or the Aetna symbol on your sort of membership card to get employees. As long as your employees know that they will have a health plan that allows them to go to the doctor, covers, the lion's share of what it's going to cost, and they're not going to be stuck with a balanced bill, that leaves you with so much more flexibility than you think it does to create a plan. And so if you don't like what your network is doing, go outside of the network. Come up with reference-based pricing plans, although hopefully under different names because they've gotten a bad rap. But this is right. This is what it should be. It should be, if you want to negotiate better rates. Try and direct contract. Try and make different types of plan design that allow you to sort of indemnify cash payment. There's a million ways to do this that are better than the current way.
I love it. I think, Julie, I'm going to ask on behalf of my audience, we're going to have you on another time, and we're going to talk about some of these other strategies and the legality side of it, because I think that's a whole nother episode of scare tactics that's coming down that's saying, if you do this, you're going to get in trouble over here and blah, blah, blah. And I got to give you a lot of props, because I have actually witnessed the letter you sent your own carrier on behalf of your own health plan at your employer saying, hey, I know what you're saying. That ain't the case. So you are a person that puts your money where your mouth is. So I appreciate that. The advisor community, what would you tell the advisor community?
Stop what you're doing. If you've embraced the CAA and you've embraced sort of helping self-funded plans in particular, but any plan, take control of its health plan, then you're already in rarefied air. You're doing great, and keep doing what you're doing, because the lion's share of the advisor community right now is resisting change. And I get it. I also don't like big change in my job. And especially if I've become used to how something works, and this is how I've been doing it for 20 years, it is extremely uncomfortable to be told, well, this is not a good way to do it anymore. And you're going to have to find a new revenue model and way you're compensated. And you're going to have to be more aggressive. And, it's sort of changing the nature of what's expected of an advisor. And I think it's going to start to we're going to have two camps. There's going to be brokers, and the broker is going to be a representative of the carrier world, of the TPA world. And then it's going to be advisors and consultants, and those people who will hold themselves out and actually be representatives of the employer and the plan, and try and come up with ideas and negotiate on your behalf and advise you on what you need to be aware of, and pitfalls and legal obligations and changes in the law. And I think that is, if you're trying to sort of retool to keep up with current changes, that's what you do, is you become an ally of the plan, because the plan needs as many people on its side right now as it can get, and there's very few. And so you all of a sudden become, more like a Lester or some of the other sort of smaller outfits that we work with, People with Benefits DNA, and places like I think you've worked with them, and the plans that you work with, who come up with alternative mechanisms to sort of give you better coverage at a lower price. These are the people you want to work with. You want to work with creative people who have new ideas. You don't want to work with people that present you with the same exact thing every year and say, guess what? It was going to be a 16% price increase, but I got it down to 12, and it's like, that's not helpful. You don't want to have your prices increasing by double digits every year. That has to stop. If you have a broker that tells you they can't carve out pharmacy benefit management, that's a huge red flag. If you have a broker that didn't even tell you that you shouldn't be exchanging rebates for administrative services and your PBM, these are all red flags that you have a real problem with your broker. And so if you're a broker, I encourage you to sort of lean into these changes, because if you do, just like for employers, it is uncomfortable at first. You have to change the way you do business, and it's more difficult than things have been, but it's more rewarding. You can actually help a bunch of clients. And right now you can stand out and build up a big client base because plans are hungry for this. They're looking for assistance and affordable guidance that will help them navigate this and figure out what their alternatives are.
I love it. I love it. I love it. And last, but certainly not least, and quite honestly, here's what I love about this last topic, right? Is if you take care of this, the other two are happy, right? Like if you focus on the actual member, the person that is the lifeblood of every organization that's out there, most rank and file are making what they're making, right? I was talking to an employer this morning, $15 an hour, and their broker's telling them to put in a $5,000 HSA. So I was like, yeah, let's do some math on this, right? $15 an hour is $37,000 a year, whatever it is. Take out Uncle Sam's. This person's taking home this. This is literally more than 20% of their net take-home pay, and they ain't got that in the bank.
That's right. And if they like living indoors or eating regularly or feeding their children, then they're going to not be able to go to the doctor, which is how it is right now.
Agreed. So what do you say to that consumer out there, that person, that employee that just, and quite honestly, every leader and every broker is a person that consumes healthcare. So this is, what do you tell everybody?
So what I tell everyone is, first of all, I'm sorry. This
Remember,
is a
the journey to getting 20%
I look at what European people that I know, and especially when they come to visit this country, they're like horrified by us. They're horrified when they see, advertisements on television for certain drugs, and that you should go to your doctor and ask for these injections. And they're horrified when they see a bill that you went and, you got knee surgery and you got a bill for $660,000. And it's just like unfathomable to people that aren't American. And it should be unfathomable to us. And you as the consumer, you're always sort of bombarded with, you need to be more engaged. You need to be a better consumer. You're supposed to be price shopping. But I promise you, your employer is unable to do it. And so don't feel discouraged that you can't do it either. It's very difficult. And so even though you're told to be more engaged, how to become more engaged really isn't available yet, and better methods of engagement need to become more available. Now, one thing that has changed drastically for all of us is the availability, one, of hospital price transparency, and two, the No Surprises Act. Put together, you all of a sudden, as a consumer of healthcare services, have a powerful tool in your own tool belt if you don't like something in your plan and you want to do things a different way. So say, for instance, you make $15 an hour and you have a medically necessary, operation that you need, or something that is happening in your life, and your insurance, you do have a $5,000 deductible, or something that will prevent you from ever having this. Well, one thing you can do is opt out of your plan. Ask for a cash pay estimate for how much that's going to cost. First of all, the research shows that it's probably going to be cheaper than what your plan has negotiated for you, which should really sting if you're an employer. What you're paying for is a higher rate than if your employees walked in off the street and said, can I pay cash? So that's what you're paying your per employee per month fee for, is a crappy discount. So if you're an individual, the first thing you do is say, I don't want to use my insurance. I want an estimate of what this is going to cost me. And that alone is a huge hurdle. It sounds like it should be simple. Hospitals will say, no, you have to use your insurance. You don't. That's one of those myths that individuals should know, is you can not only always opt out of your insurance, but you can demand under HIPAA that they not send your claims to your insurance carrier or to your third-party administrator that's on your member card. And if they do, if the facility does, they could be on the wrong side of HIPAA. And so you do have some sort of tools that you can argue. And there are all kinds of patient advocate groups out there that offer this type of assistance for free that will help you figure out, what is in my best interest. So now all of a sudden there are price comparison tools for consumers to use. You can say, I need to have, an MRI. And so there's certain, apps and tools you can go on that'll tell you the prices at like the five closest places. So one, you can pick the cheapest. You can look under your plan. You can look and see what the cash price would be and see if it is better to opt out. If you opt out, you can contact your employer and say, are there any other type of benefit plans available where if I opt out of this but save the company all this money, is some way I can be indemnified? Is there other types of assistance that you can offer? If you're a low-wage worker, is this a public hospital? Could you qualify for charity care or for reduced, a sort of reduced fee? And that is, at a lot of these hospitals, depending on what state you're in, it can be up to 600% of the federal poverty level. You can qualify for discounted or free care. And guess what? Once you're qualified, you cannot be charged more than an amount that's basically what the hospital normally collects for that service. And that's usually like 25 to 30% of what the cost is. So there are lots of ways that you personally can sort of just go outside of your plan and try and manage your own costs. And if you think you've stumbled upon something really helpful, you should go back and talk to your employer and say, is this something you can help me out with? Do you have sort of a plan vendor or a different type of vendor that can help me navigate this process if I don't use the insurance and save the plan $500,000? Or, is there another way that the company can support me so that I don't have to pay this amount to get something that I really need done? Oh, you're on mute. I'm sorry.
That is absolutely true. I was on mute. I got lawn folks here. This is live. We're doing this live. I love the ending of that because at the end of the day, that word consumerism, that word advocacy, it's got to come from somewhere, right? And, now we talk about this internally all the time. It's like, this is why I do this podcast, is so people could hear you and be like, wait a second, that's opposite of what my broker is telling me. It's opposite of what, my health plan carrier is telling me. I'm a consumer. Hey, I heard on this podcast. So it's this word advocacy, unfortunately, through misaligned incentives, it's not coming from the places historically that you would like it to come, which is the people that actually get paid to do it. I always try to get employers to understand, I don't know why you're confused that when you hand premium to somebody who calls that revenue, that your costs are going to continuously go up. I don't know why you're confused at that, but it is what it is. And so, Julie, you are doing a remarkable thing for our industry. I 1, 2, 3, 4, 5. I have at least 15 ways I'm going to cut this podcast up and teach it as a lesson, and your face is going to be splattered all over it. So because I'm out there trying to champion this. This podcast is all that we do, but the reality of it is, when somebody has a bigger name, and that's what this has turned into, is an advertising contest, right? You think because their name's on the baseball field or that it's out there, that it's safe. It makes me feel warm and fuzzy. But the reality, unfortunately, is they're sitting on the opposite end of that alignment factor.
Absolutely. And all you have to look at is like, well, what companies in America are announcing multi-billion-dollar quarterly profits? There's only one group, and it is health insurance companies. And so obviously, however difficult healthcare is and however expensive it is, it doesn't seem to be negatively affecting them.
Right. 100%. Well, Julie, if let's do this from the storm of, if an employer or an advisor, obviously we can't have your phone blowing up or your emails blowing up, but if someone says, you know what, I run a Taft-Hartley, I'm a large employer. Shoot, I heard Julie say this stuff. Where can somebody know more about you, know more about what your work is doing? Where can somebody find you?
So they can, just Google my name, go on my website, Berger Montague. You can blow up my phone. I will, in fact, talk to you, and I won't even charge you to talk to you on the phone and, just hear what your issues are and figure out if it's something that you need legal assistance with or something I can refer out to somebody that maybe you don't need a lawyer. You just need better advisors or an advisor. Just because you have a broker doesn't mean you have an advisor, and you should know this as a plan. if you're being advised, that means that somebody is suggesting to you a number of alternatives. If you instead have a broker that is just bringing you a renewal quote and saying, well, maybe we could get one other quote, but it'll be more expensive or something like that, then you're not really being advised. And so I would look at people like you who are saying, you want people that are sort of saying there are better ways to do this, because there are. And you should know, even if you don't know what's wrong right now, everyone knows there's something wrong with our healthcare system and that it's not functioning properly. So the best thing you can do is seek out the people who acknowledge that and are looking for ways to fix it and make it better.
Awesome. Well, Julie, thank you so much for being on. I've got 7 more ideas things that I think you could help our industry out. So I'll bug you later about those, but thank you for your time. Thank you for your leadership, and to our Impact Healthcare crowd. This was a gem. You're going to want to download it, save it. And quite honestly, we need to share it with every person out there, because whether you're a consumer, whether you're an advisor, whether you are an employer, we are all in this together. And the only way we start making change is to start making change. You can't pay less for healthcare until you start paying less for healthcare. And that's what this is all about. So Julie, thanks again to my Impact Healthcare crowd. Thank you so much. And we'll see you on the next episode.
Thank you for having me.
You've been listening to Impact Healthcare, people and strategies that are disrupting the health benefits industry, with Lester Morales. Remember, the journey to getting 20% savings on your healthcare benefits starts with total transparency. Remember to subscribe to the Impact Healthcare podcast on iTunes or wherever you get your podcasts.